chance, and he's going to try to be elected to be a people's representative, not a special interest representative. What everyone in this room that has spoken today has been dealing with is some aspect of ideology-based government public policy. I was impressed by Ed Bartlett. He made a comment about how his 10 principles were things that he wanted to be informed by truth and facts coupled with principles to guide public policy. What we've had has been anything but that over the last 40 years. What we've had is ideology-based public policy, and people in this room and millions of Americans across this country are paying the price for the bad outcomes of that bad public policy. So I'm actually a little bit encouraged that what I'm seeing in America is a broad-based pushback against bad government at many levels. It's why this press conference is an encouragement to me, because I know that people who normally would have spent their whole lives going about the routine, making a living, raising a family, and so forth, have awakened to the idea that government is not the solution of their problems, it is the source of their problems. Now, that is not an easy task to take on, big government. There is a momentum that has developed over the past 2 decades in particularly. It's an accelerating momentum where the reach of government into the lives of the average citizen has gotten more invasive and more detailed, and it's a power and control process that has expanded the scope of our federal government beyond anything the Founding Fathers ever could have imagined. Now, as a father of 3 children, I have sons 25 and 21 and a daughter 16. They are young people who are becoming great in their own right, but they are overcoming the deficits that were inflicted upon them by a family court system that talks about the best interest of the child but does not give a damn about the child. As an attorney, I've labored as an insider in the legal system for 25 years. What has occurred is the growth of an attitude that is pervasive in the family courts that these are not children of the parents, these are children of the state. In Alabama right now, I'm researching the possibility of federal court action because I found 1900s, early 1900s, Alabama Supreme Court cases that actually said in a divorce action, the child and the welfare of the child is the sole subject of the court sitting in equity, and the court can do anything it wants to as long as it promotes the welfare of the child, and that the parents are not even significant in the process of that judicial determination. Now, what's happened over the years is in the 60s, 70s, and 80s, we began to see a string of U.S. Supreme Court cases that say exactly the opposite. They say that parental rights are fundamental to the human condition, that they are basic to our function as an ordered society, as a civilized society, and that what we need to do is force our state governments who have this attitude that the child is a ward of the state to recognize what the Constitution says, and what it's been construed by the U.S. Supreme Court to say is that we, the parent, have primacy over the life of the child unless we've done something wrong to forfeit our primary role. It's that simple. It all boils down to whether this is a child of the state or a child of the parent. The Tennessee Supreme Court, in a case called Hawk versus Hawk, laid down what is probably the best bright line test about parental rights of anything that I've seen anywhere in the country, and it says that the requirement for proof, and I mean substantial proof, of serious harm to a child is the only protection that a parent has, a fit parent has, against invasive overreach by the federal or the state government to take over the parent-child relationship. There's an old Latin term, it's a $3 word, it's in loco parentis. What it means is in place of the parent. Now, when you're a fit parent, there are bad facts cases